Yes, good morning to you everybody. Welcome to the class. And I'm sure that you are hearing me. Please give the reply to my question if you are hearing me.
Yes, sir. Hearing, sir. Hearing.
Thank you very much. So I made the good morning sign over there, and later that we are discussing about the language canons. Then there are total six rules of language, and we did it ejustem generis, noceta resources, expressio unius est exclusio alterius, redando singulus singulis. Then in yesterday class, uterus magis valet quamperit, and today class that we are going to deal the Contemporanea Exposito Est Fortissima in Lege. I repeat, Contemporanea Exposito Est Fortissima in Lege, meaning contemporaneous exposition is the best and the strongest in the law. It is said that the best exposition of statute or any other document is that which it has. ఏమైనా అర్థమైందా అండి? ఏమైనా అర్థమైందా అండి? సిక్స్త్ చదవండి మీరు. Yes, you read it. What is there on the screen? Please read.
There are 5 rules of languages. These are ejustem generis, meaning of the same kind. Nascitur eosis, meaning a word is known by the company it keeps. Expressio unius is exclusio alterius, where the express mention of one thing excludes others. Redando singulis is a Latin term that means by referring each to each. Atres magis valeat quam perit. The maxim atres magis valeat quorum perit is a rule of construction, which literally means the construction of a rule should give effect to the rule rather than destroying it. Next one. Contemporanea Exposito Est Fortissima in Lege, meaning contemporaneous exposition is the best and strongest in law. It is said that the best exposition of a statute or any other document is that which it has.
What did you understand with the sixth one? Contemporanea Exposito Est Fortissima in Lege.
That the best exposition of a statute or any other document is the which it has.
That means what the document said, in the same intention one should have to take it. I repeat. మధ్యలో ఇస్తా, టైం ఇస్తా, మీకు టైం ఇస్తా చెప్పడానికి. Yes, I repeat. Contemporanea Exposito Est Optima et Fortissima in Lege means the best way to construe a document is to read it as it would have read when made. I repeat, the best way to read or construe a document is to read it as it would have read when made. So when it is made, what meaning it is taken, that meaning is taken into consideration, not today meaning. The doctrine of Contemporanea Exposito is well known for interpreting the statute by reference to the exposition it has received from the contemporary authority. However, it should give the way where the language of the statute is plain and unambiguous. It is considered to be the best exposition of a statute or any other document is that which it has received from the authority which is competent enough. The word of a statute should be construed in such a manner. I repeat, the words of a statute should be construed in such a manner that it had been held by the person creating such a statute in the true sense. It is considered as if they would have been as constructed as the day after the statute was passed. The rule is that statute must be considered in the light of all circumstances existing at the time of its enactment. Therefore, giving the meaning to the words that it had been the statute were construed follows logically and the courts have so held. The maxim aims at expressing that the words of an act will generally be understood in the sense which they bore when it was passed. Now you can ask me what you want to ask.
No, sir. The meaning is we have to take it as it is. That's all.
We have to take it as it is when it is enacted at the time, not now.
Of course, of course. At the time, I say.
When it is enacted at the time, you have to take that meaning, the intention of them.
So conditions prevailing at that time, it was enacted.
That is called contemporaneous. Contemporary అంటే ఎప్పుడు సైమల్టేజ్ గా నడిచినప్పుడు అరే మీ రాము మీ కంటెంపరీ యారా అంటాం. ఎందుకు 10వ క్లాస్ లో మీ రాముడు మీ కంటెంపరీ యారా అడుగుతాం. వై?
Same time.
At that time he was studying with you. సేమ్ టైం. అయితే ఆరిజిన్ చూద్దాం. ఇందులో ఎట్లా ఆరిజిన్ ఉన్నది సాల్మన్ ఏమని చెప్తాడు. ద మ్యాక్సిమ్ ఈస్ బేస్డ్ ఆన్ ద ప్రిన్సిపల్ యాజ్ స్టేటెడ్ బై సాల్మన్ దట్ ద ఎసెన్స్ ఆఫ్ లా, I repeat, I quote, the essence of law lies in the spirit, not its letter. Not its letter, for the letter is significant only as being the external manifestation of the intention that underlies it. I unquote. Actually, you have to see the spirit of the letter, not the letter signifies it. Like plant is there. What is the plant meaning? If the literally meaning is taken, if the plant is, it is a biological item and is a creeper or a bush and so. But if we internally see is plant means it is where it is contextual sense, it plant means it is a place where the manufacturing unit was there and which spoils the environment. So when the environment would be spoiled over there, we have to take that meaning which is prevailed over at that time, that spoiling is concerned. That meaning should have to be taken into consideration, not the today's meaning it should be taken. So interpretation is considered to be the way of finding out the true sense of an enactment by the virtue of recognizing the natural or nature and ordinary meaning of the word in any enactment. In other words, it is observed as the process of ascertaining and finding out the true meaning of the words used in any statute. The court over the years has laid down many principles for interpretation so that interpretation does not amount to be arbitrarily. Thus the maxim Contemporanea Exposito Est Fortissima in Lege, which means that contemporaneous exposition, means at that time contemporaneous exposition is the best and most powerful in the law is formed. When the law is enacted over there, at that time, what is the exact meaning of the enactment of the parliamentarian or state legislator did it at that time, that meaning should be taken into consideration, not the present meaning should have to be extracted or known. So that is the thing. Let us see the illustration. By illustration, what it means. If any document or any statute is made, actually it is not made, it is made for a special group of people and they are represented by a particular word, then that word will indicate that group of people until unless otherwise mentioned. ఒక స్పెసిఫిక్ గ్రూప్ ను ఒక వర్డ్ యూజ్ చేసినప్పుడు తాగుబోతోళ్ళు, it is a specific word which is given over there, the person who has taken the intoxicated drinks. తాగుబోతుడు అంటే ఈవెన్ నీళ్ళు తాగినా తాగుబోతుడే అవుతాడు. అవుతాడా కదండి? తాగుబోతులు is a plural, తాగుబోతుడు is a singular. So here, what is the intention? What is the intention of the parliamentarian? తాగుబోతులు or తాగుబోతుడు? What is the idea behind them? Yes, tell me.
Tagubotu is a singular and Tagubotulu is a plural, but both are with the equal this thing. What we say?
Who comes under it? Who comes under this Tagubotulu or Tagubotudu?
Not do Tagubotu. That's all.
Yes, Tagubotu. Okay, let us bring Tagubotu. Who will come under this definition?
The fellow who consumes the liquor. Liquor is a Tagubotu, and the singular and plural. But if their habit is the same, the quality is the same, that's all.
We have to ascertain exactly the person who consumed the alcoholic substances, which produces the hallucination, which produce the a man become a insane a time being, and that substances person who consumes is said to be a drunkard. So that meaning should be taken into consideration at the time when it is enacted over there. But general meaning should not be made it over there, because that is not the intention of the parliamentarian. We say if a person who drinks even water also called a drunkard, but that drunkard will not be taken into consideration. That people will be taken into consideration. That intention, what they made at that time, the parliamentarian drunkard refers to the persons who drinks or who consumes the alcoholic drinks which produce the hallucination. They say alcoholic drinks and so, but does it mean that whether the brown sugar or cocaine and charas also comes? Answer say yes, it is extended to that one also, because those are psychopathic substances which produces the hallucination. So a thing which will produce the hallucination or make and made absent-minded to a certain extent because of the intoxication or because of the alcoholic things, at that instance, that meaning will be taken into drunkard. So drunkard is not only the person who has consumed the alcoholic drinks, even the addict also comes under it in general sense. Addiction. So when it is means, suppose if they say such substances are prohibited, if you say such substances prohibited means even alcoholic drinks are prohibited, psychopathic substances are prohibited. But now at present in the government of Telangana, what is prohibited?
Telangana government, no prohibition, sir. Prohibition is all lifted, sir. No prohibition. No.
So one can take the psychopathic substances.
Acha. You mean drugs? Drugs are not allowed.
That means you can consume the alcohol, which is a licensed alcohol, but you are not supposed to consume the psychopathic substances because the law prohibited it.
That is non-Indian-made foreign liquors, we say.
Why? Foreign liquors, one cannot consume it here in India?
Not, sir. Indian-made foreign liquors.
Why Indian-made? Directly imported foreign liquor can't be consumed here, which is sold in the customized shops?
Sir, that also you can take, no problem, sir. But it is,
see, in the custom-free shop, you will get all foreign liquors.
Foreign liquors, yes.
When you are coming out of the station, airport, because if you produce your card, you will get at least 2 bottles foreign liquor without any taxes.
Where, sir? Where?
Airport.
Shamshabad, mein?
If a foreigner coming down to India with a foreign passport, visa, he can get the 2 bottles of liquor of foreign made without any customs. Any doubt? Any doubt? Yes, let us come to let me proceed if there is no doubt. Let us proceed if there is no doubt. Yes, now we'll see some of the, here I can make it out yes, Contemporanea Exposito External, these are called external aids, and this is the first slide which I want to share with you. Then the second slide which I want to make it out is introduction is concerned. Interpretation means the art of finding out the true sense of an enactment by giving the words of the enactment their natural and ordinary meaning at that time when it is enacted. The second bullet is, it is the process of attaining the true meaning of the words used in a statute at that time when it is enacted. Number 3, the court is not expected to interpret arbitrarily, and therefore there has been a certain principle which have evolved out of the continuous exercise exercised by the courts. These principles are sometimes called the rules of interpretation. Then the last point, Buradi, is the object of interpretation of statute is to determine the intention of the legislature conveyed expressly or impliedly in the language used at the time when it is enacted. Any doubt? If any doubt is, please ask me now, so that, or you can say proceed. Yes. భక్తులారు ఉన్నారా లేకుంటే భక్తులారు బయటకు పోయారా? If you say proceed, then I can go ahead. It gives the sense that you are not present if you don't say proceed. If you say proceed, I can go further. If you don't say proceed, that means you are not present. Only you are present with your mobile, but physically you are not present. That gives the sense to me. Yeah. That is give the sense to me that you are not present over there. But anyway, that I will try to make it out. The object of interpretation of the statute is to determine the intention of the legislator conveyed expressly or impliedly in the language used. So that is the slide which I want to make it out for your understanding. So next slide we can see it. These sixth canon is said to be the aid to interpretation. It is the aid to interpretation. It is generally external aid or internal aid. So we can take it in the both the sense, whether it is the external aid or internal aid. What is the meaning which is given over there? Actually, when the act is made, the true sense of that word would be expressed rather than the present sense of the word would be expressed. That is the idea behind it. Please say, did you understand? Shall I proceed? I am not getting the answer from you. It means that you are not present over there. That gives the sense to me.
Proceed.
That gives the sense to me. If the answer is not there, that gives the sense to me that you are not proceed. Now I got the answer means you are present over there. Yes. Next. Yes, now the question comes, sectional aid. Generally we say that no historical background, original and legal dictionary, debates and juridical construction. Generally we will say these are the external aids. So the sixth canon is said to be it will act as the external aid as well as the internal aid. So it can be both the way it can be acted because it gives the true intention of the legislature at the time when it is made. So Contemporanea Exposito, that is the Contemporanea Exposito means that the meaning of the words in a document are to be understood in the sense which they are bore at the time of the document. So at the time of the document means when it is enacted. That is the meaning. At the time, what is the intention of the person which will set over there? Suppose such intention is not clear over there, then we use another maxim, then we use another rule, so that the intention of the legislator and the statute may not become a void. In one way, in another way, we see that the statute can be used, what we saw in the fifth canon. Now come to the Contemporanea Exposition is the best and the strongest in law. It is said that the best exposition of the statute or any other document is that which it has received from a contemporary authority. Contemporary means at that time, contemporary authority, contemporary situation, prevailing at the time. So Contemporanea Exposito Est Optimum means usage or practice. See the word they used, usage or practice developed under a statute is a indicative of the meaning ascribed to its words by contemporary opinion. Yes, I will give the chance now you to ask the question. Yes? Any question or shall I proceed?
Proceed, sir. Proceed.
Yes. Because I heard your voice, that's why I stopped. When I heard the voice, automatically I said the three things. What are the three things? Can you repeat? Say yes or no. I will give the answer to your question.
Sir. Okay, sir.
My legs are fettered, my hands are handcuffed, my tongue is tied. Repeat.
Sir, Contemporanea Exposito.
లేదు, నేను ఇప్పుడు చెప్పిన మూడు చెప్పిన రిపీట్ చేయండి.
అదే సార్
నేను లెగ్ అన్నా, హ్యాండ్ అన్నా, టంగ్ అన్నా, అది రిపీట్ చేయండి. Just now I repeated, no? My legs are fettered, my hands are handcuffed, my tongue is tied. Repeat.
Sir,
Repeat.
everything is okay. You can proceed, sir. You can proceed, sir.
ఎందుకంటే దీని వల్ల ఏం చేస్తుందంటే మెమరీ పవర్ అనేది తెలుస్తుంది అన్నట్టు. ఏ మ్యాన్స్ మెమరీ పవర్.
Shall I read these 3 points? So
No, don't read. I repeat what I said.
Achha.
Repeat what I said.
Yes, sir.
Repeat. Legs, hands, tongue. Repeat. It shows how your sharpness would be there. I repeat.
Sir, you mean you want me to tell the meaning of this contemporanea?
అది కాదండి, మీ దండం పెడతా. ఇప్పుడు చెప్పినవి రిపీట్ చేయండి. మై లెగ్స్ ఆర్ ఫెటర్డ్, మై హ్యాండ్స్ ఆర్ హ్యాండ్ కఫ్డ్, మై టంగ్ ఈజ్ టైడ్. రిపీట్.
Not necessary, sir. You can proceed.
Okay. The point is, when you make any disturbance while you are, my lecture is going on, automatically the 3 things will happen to me. But I will give the time to you to speak. I will ask
Yes, sir.
any other question. At the time you have to speak, but not in the middle. But not in the
Yes.
middle. That is the procedure one should have to adapt it. Yes, I will give the time to you to ask the question. And then, shall I proceed?
Yes, sir. You can proceed, sir.
Very good, very good. That is the spirit. That is the spirit. Otherwise, I will tell you what is leg, what is hands, and what is tongue. Okay. Applicability of the maxim Contemporanea Exposito. When you have to apply it, the maxim Contemporanea Exposito is applicable in construing ancient statutes, but not to the interpreting the act, which are comparative modern. So now we have to see what are the old statute at the time, what it says about it, what is the actual meaning at the time. That should be taken into consideration, but not to interpreting the acts which are comparatively modern. So the modern acts, we should not compare it. It should be applicable. Mostly there was the act, what the meaning has given at that time for that word, that will be taken into consideration, but that not the modern word. Yes, in modern progressive society, it will be unreasonable to confine the intention of the legislator to the meaning attributable to the words used at the time the law was made, unless a contrary intention appears, and interpretation should be given to the word used to take in new facts and situations if the words are capable of comprehending them. That means we should not apply the new meaning. We should not stress the new meaning. We should make exact meaning what the time, contemporary time, that word actual meaning and what is the intention at the time the legislator make it. That meaning only will be taken, but not the modern meaning. The Supreme Court has refused to apply the principle of Contemporanea Exposito to the Telegraph Act 1885 and the Evidence Act 1872, but the principle is applied in construing the Bombay Municipal Corporation Act 1888. The reason they say certain times, no, this act, these canons cannot be applied for the modern things. At the time, telegraph was there, but do you have the telegraph now?
Not really, sir.
At the time, telegram was there, which is the fastest way to send the message. Generally, people used to send the telegram. Telegram ఎప్పుడు పంపిస్తారండి అప్పుడు చెప్పండి.
Actually, if they see the telegram, there some frighteners will be there. If anybody expired like that.
If anybody is expired, if any other most important job is there or date is there, last date is there, if any emergency is there, at that time telegram can be used. Yes. Do you want to contribute? You can contribute. Yes. Yes, please contribute.
Yes, sir. When anybody is coming urgently like that.
Any other thing?
No, sir, no.
Shall I proceed?
Yes, sir, you can proceed.
Very good, very good. So that is the spirit. So now we will see that what is the next slide will say, limitation of the maxim, the Contemporanea Exposito, and useful only in case of ambiguity. The usage and practice can be used in interpretation when the language is ambiguous only. If the language is unambiguous, the usage and practice cannot be used in interpretation. So generally, when the words are very much clear, what the intention they made it, at that instance, yes, it is very much clearer. The way that we can make it out, the same meaning would be given over there. Now the question comes over there. Gift. Gift anedi bribe kada.
Gift is not a bribe, sir. But under the conditions you give that gift, it may become bribe also.
On the conditions when you give the gift to a particular person, the contextual meaning, the gift becomes a bribe.
Right.
Yes.
If it is given openly, it's not a bribe.
See, I don't know. Again, the Twitter is there. Chief Justice Babde used the helicopter or the chartered plane of Madhya Pradesh government to visit the national park. It became a big issue now because all the MLA's cases are on his table and he is going to dispose it. I am sure that it is in his own bench. It is there.
Wow.
So anyway, that is a debatable talk would be there because whenever a person having any case of such a nature would be there, naturally we should be try to avoid such a person's company or such person's what I say, the facilities. What I want to say, being an academician, I am saying this one. Anyway, that is my is only the my express my opinion regarding the point is concerned. So here it will be deemed that meaning will come over there. Yes, custom is given more value and priority than act of the parties as illustrated in the Constitudo. Constitudo, that custom is the best interpreter of the law. Then the another point will says there, useful only for the ancient acts and can't be used for the modern acts. So the only ancient acts can be, the old acts can be used over there. Such a limitation is there for this sixth canon, but cannot be used for the modern acts. So the people say a judge is like a saint. Any comment? A judge like a saint, S-A-I-N-T, saint. Asal అర్థమైందా నేను చెప్పింది? Did you understand what I said?
No, sir. Please repeat.
S-A-I-N-T, S-A-I-N-T, saint అంటే అర్థం?
Saint is a holy person. Okay.
A holy person. A holy person never go to the casino. A holy person never go to the brandy shop. A holy person never go to the gambling house. A holy person never go to the dancing or club dance. A holy person never go to such any places. Now you say. Now you say.
Sir, before that holy person, you uttered something, sir?
I did not utter anything.
Cannot be applied in case broken is.
I say a judge is like a saint. I say
a judge.
A judge. J-U-D-G-E. A judge is I-S is like a like a S-A-I-N-T, saint. Now you contribute. Now you contribute.
A judge need not be a saint.
But the people say a judge should be a saint.
Nyaya Devata we say, but a judge is a employed person. Okay, he did not be a saint.
Can you go to the bar?
He may consume liquor at his house.
I asked the question to you. Can he go to the bar?
He cannot go to a bar. Okay.
Why? Because suppose the bar manager case is lying in his table, then people will think in different way.
He may be attributed other unnecessary things.
That is the reason. That's I said a judge should be like a saint. Any comment?
Yes, sir. The qualities of a saint are different from that of a judge, actually.
I agree.
A judge sahab, A fakir sahab रहता, सब fakir रहता. Fakir we cannot compare a fakir with the
No,
saint.
no. The fakir cannot be a saint.
I'm sorry, not fakir sahab. So mullah we say mullah.
Mullah is a spiritual man.
But sir, a saint is a number one is a saint is
He is all in one in all.
a spiritual man is a saint actually. But
All is one and one in all. He is a saint. He is a good educationist. He is a good orator. He is good in the spiritual. He is good in many aspects, and such qualities generally will be attributed to the saint.
But the judge did not have all these qualities as a saint.
My point of giving is a judge cannot go like you and me.
That is okay. That is okay.
So generally we will say a judge is like a saint. I say like a saint. I say like a saint in the sense not 100%, at least some percent.
Thoda.
So like అనేది దాన్నే అంటారు. Like అని ఎందుకు అంటారు అంటే 100% కాదు కాబట్టి like అంటారు. The like we will say use the word. Okay, let us see in the AP Rangaswamy versus State of Karnataka లో ఏమంటారు. It was observed that when public premises is leased or sold or mortgaged to some person, three words are used over there. If the public premises is leased or sold or mortgaged to some persons, it is to be done only under the provision of law. Only on the provision of law you have to do it. Otherwise, such public places you cannot sell it, you cannot lease it, you cannot mortgage it. So, yes, contribute so that I could go further. Yes.
That is under the provisions of some property law. That's all.
What is property law? Tell me.
Yes, mortgaging or selling or leasing.
Can you sell the public place?
Public place, sorry. It is by the government now, not by the individual parties.
It is by the leased or sold or mortgaged of the public place only when there is a act will enable you to do so.
By the government only.
Any act will be enabled to do so.
Sir, Land Acquisition Act. Land Acquisition Act.
Land Acquisition Act is an act. Any other act, even the cess, even the recently, what is that going on now? The TRS government, what is it? LRC or TRS? What is that?
Dharani portal is there.
Dharani portal is there. You should have to first people challenged on it. How could a person will introduce it without an enactment, without a proper procedure would be followed? Yes, come to the point again. Yes, sir. Come to the point again here. You are leasing the property of the government or municipality or a corporation, which is a public property, shall be on the basis of the distributive order, and the persons of the society from a different walks of life should be given an opportunity. When the premises is granted to a particular person, he has to utilize the same and shall have give if it is a public place, he cannot supposed to drink. An opportunity to other person who are in queue. So when a person want to use the public place, he should have to use it to his needs only, but he cannot make it out for his own for the entire time, because he will give the opportunity to others also to use the public place. ఇప్పుడు పబ్లిక్ గార్డెన్ ఉన్నదండి, ఉయ్యాలాలు ఉంటాయి పబ్లిక్ గార్డెన్ లా. ఇక మీరు పొద్దుగా నుండి సాయంకాలం వరకు మీ పిల్లలే ఊగితే మరి మిగతా వాళ్ళు ఏం కావాలండి?
The caretaker should take the responsibility.
The caretaker will definitely say, అమ్మా మిగతాలో కూడా ఉన్నారమ్మా, కొంచెం వాళ్ళకు కూడా ఛాన్స్ ఇయ్యండి అంటారు. Yes. So the other people are the queue, those who have given the chance to use the public place, because public place it can be used by public, and okay, public place it can be given for the lease for the exhibition purpose.
That is for public purpose only.
But again, that is public purpose.
That's all.
So when an agreement is entered into between the parties to a clear terms untai danlo, the agreement prevail over the unless it is alleged that the agreement itself is fraud. So whenever you are giving anything is for the public, it is for the public purposes through the process of law. Through the
Of course, of course.
process of law. Due process of law should be allowed.
As per the provisions of the Act also.
Yes, either with the license or with the permission or with any other thing. Such a permission is granted or renewal is made under these circumstances. Then petitioner you have approached the court. The quite contrary to the agreement is there. So at that instance, one should have to. Yes. Yes,
By
tell
the
me.
competent authority only. By the
By the
competent
competitive authority only should be made it over there. That can be made. Yes. So suppose now in the depots or in the bus stands, there are shops are there around the bus stand compound. There are shops are there. So the shops are either every 3 years or every 5 years it will be tendered.
standard. Yes, sir.
And people generally they will change the names and they will fill the tender and they will get it. That is a different practice. That is again. But the point comes, it is not on the same person name. It will be renewed because there are many other people are there in the queue, those who contest for the tender. So an agreement of a private person can't derogate from a public right and apply in all four of these cases. So under these circumstances, petition fail and according are liable. So what I want to say in this case law is when this canon can be used over there. When the canon can be used at that instance, what is the purpose at the time the word is used? That contemporary purpose or situation meaning will be taken into consideration, but not the new meaning which is prevailing now can be considered. That
Yes, sir.
that is the actual intention which want to make it out. So let us see the another slide. Conclusion lo em cheppalante the object of interpretation of statute is to determine the intention of the legislature conveyed, expressed, impliedly, expressly in the language used at the time when they enacted. Number one. Number two, to assist the task of interpretation. I repeat, to assist the task of interpretation and construction, court resort to certain internal and external aids. So they will also check it. What are the internal aids? What are the external aids? To make it the sense that the word is used in that particular sense at that time by the parliamentarian, by the legislator. So these internal and external aids to interpretation is very essential at the times to construe ambiguous terms and provisions. Yes. You can take internally the meaning, you can take externally the meaning. Because immovable property, it is not specifically mentioned in the Transfer of Property Act. From where we are taking the definition, immovable property? Yes.
Immovable property, sir.
Where we are taking the definition, when the definition is not clear in the Transfer of Property Act. I told several times,
Yes, sir.
the definition taken from the General Clause Act of 1897, if I not be mistaken.
1897.
For the majority, from the Section 11 of the Indian Contract Act, which clearly state the majority act of Section 3 will say about the who is the major, who is the minor. A person who crossed the 18 years of age is said to be a major, but a person who under the custody of the guardian and his age is 21 years
21
as per the Guardian and Wards Act. So the third bullet says Contemporanea Exposito, short form. Contemporanea Exposito is a short form, is an important external aid in interpretation of the statutes. The usage and practices followed after the enactment of the statute speaks for itself, but this can be applied only to very old statutes and has a little importance in the modern statutes, because the modern statutes give a different meaning for the different words, and the old statute, it is only given one meaning at the time which is prevalent over there. Now the crime, you will say, at the time crimes are only traditional crimes. But if you say crime now, even cyber crime also a crime.
Of course, sir.
because is a new trend. The crime concept, the crime definition is changed. Now hacking and stalking and harassing through the internet is the new type of
Yes,
the
yes.
crime is there. And hence we can say it is a cyber crime. A new name is given instead of giving the old traditional heinous act like murder, rape, dacoity, riots. Those were traditional crimes at the time, but the new definition which is given over there at the time, crime means that only taken into consideration, but the new not new concept of the crime will be included over there. At the time, the cyber even internet was not there. సార్ మీరు ఇంటర్నెట్ ఎప్పటికెళ్ళి యూజ్ చేస్తాను సార్ అంటే ఎప్పుడు మీకు తెలిసింది ఇంటర్నెట్ అనేది
5 years, sir, 5 years.
Before that, you don't know what is cyber, what is hacking, what is email. At the time, people used to write only the letters, postcards, inland letters, or foreign letters. That is, which goes to the foreign country. That is, the foreign letters would be there in the whose stamping will be different from the inland letters. But nowadays, nobody is making or sending by post. Very rare occasion where the physical sending of the biodata would be there. But the modern time is you can give where they are giving their email, either email you can send your attachment, or they are giving the link, online link, you have to fill everything online, you have to load it online. Even for the renewal of your passport. చెప్పండి ఎందుకంటే మధ్యలో చెప్పింది అనుకోండి నేను ఆగిపోతా
You please continue, sir. That will tell you the last one.
Yes. So while you are renewing the passport, while you are renewing your even any card, now your license also you can renew it on the online. There is the online facility is given over there, but only one thing is there: you have to go physically for biometrics and keeping your signature only. You have to go there either to the passport office or to the RTA office. Now you can continue.
Sir, is there any overlapping provisions for this hacking, the Cyber Crimes Act and the IPC?
See, generally, a thing which is not covered over there in the IPC, a special act would be made to cover it. Hence, a broader respect, IPC says crime, but a narrow and particular point where the Cyber Act will say.
Specific act, cyber.
Even IPC will cover the accidents, but the Motor Vehicle Act is there.
Of course.
Even IPC cover the dowry. Even the Dowry Prohibition Act is there. A thing which is specifically maintained over there, a thing which will specifically dealt over there, a thing which is clearly made it over there, a special act would be made. And the special act is supplement to the IPC, not derogatory to the IPC. Now you can comment.
It is a mother act actually, the IPC.
Other acts are supplement. The main act is Grannam is IPC. The mother act is IPC. Others are only supplement.
Supplementary act.
Specific act, specific statutes, special statutes are there. But IPC is IPC. Still it will continue because it is made in such a way. So many sections also can be brought under it when you make a subdivisions. And others, if they say enough. In others, everything will fall.
Of course.
It is called blanket clause. It is called blanket clause, or we can say residue clause. You can say blanket clause, or you can say residue clause. So this is the actually a thing regarding this maxim is concerned. I recorded it, and for the benefit of the absentees, for the benefit of the even people who are present now also, it will be useful to them. I said already that if one man also get benefited out of my lecture, my mission is fulfilled. So with this, now the time is 12:16, and tomorrow we will see, because now the canons are over. So tomorrow class, let us deal the next. I will show the question paper. Then we'll see what will be the next class we will deal in interpretation of statutes. Yeah, we saw it here.
Sir, the rules of construction under the General Clauses Act, that is over, sir. Okay.
Okay.
General principles of interpretation, फिर बोलना.
Okay. So, yeah, tomorrow we will see. Can we see the General Clause Act?
General Clause Act, we have already. Okay, sir. Again, section 6.
Section 6. Section 6, Section 7, Section 10, Section 11, Section 12, Section 14. General rules. General rules of construction.
Actually, it is the mother. Actually, it is the mother of the act.
Mothers of all laws. Laws of all laws, not mother of all laws. Laws of all laws.
Laws of all laws.
Yeah, Section 6 to Section 14, we will see tomorrow class. How many sections we can cover? From Section 6 to Section 14, these called General Rules of Construction in the General Clause Act. That we will see tomorrow, and I will post it also. Let the people will be benefited. With this, I would like to close my today's session. Now I include 3 minutes on your time. With this, I would like to stop it, stop sharing. Then I will load it to your, yes, I will load to your, leave the end of the meeting for all. Yes, end meeting.